Hi, I'm Dan Chambers of Chambers Law Firm. In this particular video, I'm going to talk about federal plea bargains. Now, federal plea bargains are way different than what you're going to encounter in a state court in California. When you go into state court in California, most of the plea bargains are negotiated between the prosecutor and the defense attorney, or sometimes the judge will give what's called an indicated sentence. He or she will simply throw out a potential sentence if your client pleads guilty, and it's more of a negotiated plea where everybody knows what's going to happen. So for example, if you're charged with a drug crime, possession for sale of cocaine in state court, and you sit down with the DA and you hammer out a deal for, let's say, 2 years, everybody knows exactly what the sentence is going to be and approximately how much time you're going to serve on that sentence. Things are way different in federal court. Most of the time in federal court, if you negotiate a plea agreement with the U.S. Attorney's Office, you both sign what is basically a very lengthy agreement, usually in excess of 20 pages. It's got a lot of terms and provisions, and it's signed at the end of it by the defense attorney and the defendant himself or herself. Now, what makes it so different than state court is the fact that you don't know what sentence you're going to get. Now, in the agreement itself, the U.S. attorney and the defense attorney will agree to what's called the offense level, how serious is the crime, and they'll usually agree on the defendant's criminal history score, and they'll plug into those sentencing guidelines that I talked about in another video, and they'll draft up the agreement to say the expected sentence based on the guidelines is somewhere between 40 months and 52 months, say. But there's no guarantee the judge is going to go along with that. So it can be a very, very nerve-wracking experience for the defendant knowing that they're agreeing to plead guilty and not knowing what the sentence will be. So once the agreement is signed and the defendant pleads guilty, you have to go before the judge for sentencing. Now, the judge probably will follow those guidelines of 40 to 52 months, but you don't know that. The judge may have a completely different look at the case, and the defendant could face substantially more time. And here's how it's really different. If you were to have that particular judge that says, no, I'm not going along with that, I'm going to give the defendant 60 months, you've already bargained away your right to withdraw your plea, because one of the provisions in that agreement that the defendant typically signs is, hey, I'm not getting any guarantees on sentencing, and I know that I can't back out of this plea bargain or this plea agreement once I've signed it. So you have to be very careful to know your judge and know what's likely to happen. It also makes sentencing way more important. You have to go into court prepared to argue for your client about mitigating factors and perhaps even argue for the judge to go below the recommended minimum sentence. So it's a complicated deal, and it's very different than state court. So if you have a federal case and you're thinking about entering into a plea bargain, make sure you call Chambers Law Firm so we can walk you through the rights that you might be giving away and the uncertainties that might surround your sentence. We always provide a free consultation, and we'll be happy to talk to you. Thanks.